a letter arrives. It is not from your credit card company. It is not a bill. It is a court summons. A debt collector is suing you. And somewhere at the bottom of the page, there is a deadline. Miss it, and you lose automatically. Not because the collector proved anything. Not because a judge reviewed any evidence. Simply because you did not respond. This is how many debt collection lawsuits end. The person being sued never shows up, never files a response, and the collector wins by default. Every source cited in this video is linked in the description and listed at the end. Everything comes directly from the Fair Debt Collection Practices Act, the Consumer Financial Protection Bureau, and the Federal Trade Commission. Before we go any further, I want to say that I am not a lawyer. This video is purely for educational purposes only, not legal or financial advice. A debt collection lawsuit starts with two documents. The first is the summons. It tells you that you are being sued, which court the case is filed in, and the deadline by which you must respond. The second is the complaint. It lays out what the collector claims you owe and why they believe you owe it. These two pieces of paper are the collector's entire opening move. Everything they are claiming is right there on the page. And here is what most people do not realize. You do not have to agree with any of it. You are allowed to fight back. You are allowed to make them prove every single claim, but only if you respond by that deadline. Most people get this envelope and panic. They shove it in a drawer. They assume it is already over. It is not. This is actually the moment where you have the most power, if you know what to do with it. If you ignore the summons and do not respond by the deadline, the court enters what is called a default judgment. The collector wins. Not because they proved you owe the money, not because anyone reviewed the evidence. You simply did not show up, so the court gave them the win. Once the collector has a default judgment, they can ask the court for permission to garnish your wages, freeze your bank account, or place a lien on your property. A judgment can also appear on your credit report and affect your ability to get credit, housing, insurance, or even a job. And here is what makes this so frustrating. In many of these cases, the person being sued could have challenged the debt, forced the collector to prove their case, or negotiated a settlement for less than what was claimed. But they never got that chance because they never responded. The Consumer Financial Protection Bureau is direct on this point. You have a much better chance to fight a collection in court if you defend the case than if you wait until a judgment is entered against you. The default judgment is not about whether you owe the money. It is about whether you showed up. That is the entire difference between losing everything and having a fighting chance. Your response to the lawsuit is called an answer. It is a written document you file with the court. In it, you go through each claim the collector made in their complaint and respond to it. This is how you put your side of the story on the record and raise any defenses you have. This is important. You do not have to prove that you do not owe the debt. When you respond to the lawsuit, the burden shifts to the collector. According to the Consumer Financial Protection Bureau, a debt collector has to prove to the court that the debt is valid. They must show that you are the person who owes the debt, that the amount they are claiming is accurate, and that they have the legal right to collect it. Many debt collectors file lawsuits expecting no response. If you answer, you are already in a stronger position than they anticipated, and responding or showing up in court might help you settle the debt. Because according to the Federal Trade Commission, some collectors would rather settle than go through a long and expensive lawsuit. When you file your answer, you can also raise defenses. These are legal reasons why the collector should not win, even if the debt once existed. First, the statute of limitations. Every state sets a time limit for how long a collector has to file a lawsuit. If that deadline has passed, the debt is time-barred. Under federal law, a debt collector must not bring or threaten to bring a legal action to collect a time-barred debt. If a collector sues you for a debt that has expired, the Federal Trade Commission advises you to show up on the day of your case and tell the court the debt is time-barred. To prove this, bring a copy of the debt information from the collector or anything that shows the date of your last payment. Second, the collector cannot prove they own the debt. Debts are frequently sold from one company to another. The collector must be able to show the court a clear chain of ownership from the original creditor to them. If they cannot prove they have standing to sue, they do not have a case. Third, the amount is wrong. The collector must prove that the amount they are claiming is accurate, including any interest or fees. If they cannot provide an accurate accounting of what you owe, that is a valid defense. And fourth, if the collector violated the Fair Debt Collection Practices Act during the collection process, you may be able to countersue. The Federal Trade Commission confirms that you have the option to sue a collector in a state or federal court if they broke the law, if they called before 8 in the morning or after 9 at night, if they threatened you with arrest, if they misrepresented the amount. Those violations can work in your favor. You have 1 year from when the collector broke the law to file your lawsuit. A lawsuit is not a conviction. It is the beginning of a process. And in that process, the collector has to prove their case. You do not have to prove yours. Even after a lawsuit is filed, you can still negotiate. The Federal Trade Commission confirms that some collectors will accept less than what you owe to settle a debt, and the Consumer Financial Protection Bureau notes that if you owe the debt, you may be able to work out a settlement or other resolution with the collector. Responding to the lawsuit puts you in a position to negotiate, because collectors often prefer to settle rather than go through a full trial. If you go this route, make sure any agreement is in writing before you make a payment. If you have received a court summons from a debt collector, here is exactly what to do. Read the summons and complaint carefully. Note the deadline. Note the court. Note every claim the collector is making. File your answer before the deadline. Respond to each claim in the complaint. Raise any defenses that apply, including the statute of limitations. If you cannot afford a lawyer, contact your local legal aid office. The Legal Services Corporation has a search tool at lsc.gov. You can also visit lawhelp.org. Many courts also have self-help centers and answer forms available at the courthouse. The Consumer Financial Protection Bureau confirms that you do not need a lawyer to respond to a debt collection lawsuit. You can respond personally or through an attorney. Consider negotiating a settlement. Even after being sued, many collectors prefer to settle rather than proceed to trial. And if a default judgment has already been entered against you because you did not respond in time, you may be able to ask the court to vacate it. But the Consumer Financial Protection Bureau is direct on this point. A judgment is a court order, and it can be very difficult to get it changed or set aside once the case is over. If you had a good reason for not responding, or if you were never properly notified of the lawsuit, a judge may agree to reopen the case. But this is not guaranteed, which is why responding before the deadline is so critical. Getting sued by a debt collector is stressful, but it is not the end. It is the beginning of a process where you have rights, you have defenses, and you have options. The worst thing you can do is nothing. The best thing you can do is respond. If you have not seen it yet, the first video in the series explains everything that happens before a lawsuit, including the one letter that can stop a collector from collecting until they prove the debt is real. That video is right here. And if a collector has already won a judgment against you and your wages are being garnished, you need to understand the federal and state laws that limit how much they can take. I break that down in the next video. Subscribe so you do not miss it.